Further hearing in the appeals, Warner-Lambert Company against Generic UK Limited and another.
My Lords, good morning. Can I begin with the point of law on claim construction? Because we submit that if and to the extent that the claim is otherwise ambiguous, it should be given a construction which validates rather than defeats it. The principle ut res magis valeat quam periat. It's better for a thing to have effect than to be made void. And we say that principle applies to patents as it applies to contracts, to deeds of settlement, and indeed in public law instruments. That principle was not controversial in the 19th century, and we've cited authority to that effect. For example, Lord Davy in the Parkinson case, which I don't ask your lordships to turn up, but it's Authorities Volume 4, tab 38, MS 2788, and it's page 411 of the authority. And there are more modern expressions of approval for the validating construction principle in patent law, in particular Mr. Justice Neuberger, as he then was in the Kiran Amgen case, Authorities Volume 3, tab 29, MS 2346, and it's paragraph 286. Again, I won't take time on it, but his lordship expressed approval in the patents context for the statement by Lord Brougham in the deed of settlement context, which is the one of the origins of the validating approach principle. My Lords, more recently, this principle has gone out of fashion in patent law by reason of the observations of Lord Justice Sedley for the Court of Appeal in Smith, Klein, Beecham. And I do ask your lordships, please, to go to that. It's volume 1 of the authorities. It's tab 7, MS 1504. And the relevant passage appears at MS 1531 in Lord Justice Sedley's judgment, which, as I shall show your lordships, Lord Justice Aldous agreed. And at 103, paragraph 103 on MS page 1531, his lordship refers to Article 69.1 of the EPC as expounded by the protocol, and I'll come back to that. And he then says, because the law has historically been suspicious of monopolies for well-known reasons of public policy, there is no useful analogy between a patent and a deed or a written contract. The latter two will have been drafted for a purpose, which, assuming it not to be illegal or contrary to public policy, the law will do what it properly can to uphold. A patent, by publicising an invention, makes it the patentee's sole property for 20 years, so the patentee's immediate interests are in opposition to those of the rest of the world. It is in society's longer-term interests that by settling the two things in balance, genuine innovation should be protected and rewarded without stifling further invention. Lord Davies' approach, that's the validating principle, any analogue of it would reward opaque drafting as objectionably as the infringer's defence in cases like Edison phonograph seeks out opacity, when on a fair-minded reading there is none. We respectfully disagree with that. Lord Justice Aldous, your lordships will see, expressed agreement with that at paragraph 10, which is on MS 1510. His lordship didn't add any reasoning. His lordship simply expressed agreement with Lord Justice Sedley on this.
Paragraph?
Paragraph 10, my lord. It's on page
I've got
MS 1510, paragraph 10.
It's the penultimate sentence, yes.
Yes, indeed, Lord. In our submission, there are strong reasons of public policy for seeking to uphold as valid a patent claim if it is properly ambiguous in construction. If it satisfies the tests of novelty and of sufficiency, then there is every reason in the public interest to seek to uphold a patent in order to encourage the investment required to produce inventions that benefit the public interest.
Well, you say if it satisfies those tests.
Yes.
But the whole purpose of the construction which you are proposing is to allow it to satisfy those tests. So there's an element of circularity about this, isn't there?
Well, there's an element of circularity, but the court should seek to arrive at a conclusion, if it can, if there is genuine doubt that novelty and sufficiency are protected. The issue is what does the claim mean, not whether there is sufficiency, not whether there is invention. One's
Yes,
asking.
but the reason why you are proposing this principle of construction is that it leads to the conclusion that the claim must be sufficiently narrowly construed to satisfy the sufficiency test.
Yes.
So we are concerned with sufficiency. We can't assume it. It's what you're getting at.
No, but the law, in my submission, should adopt a public policy that if it can, it should reward that which reasonably construed, properly construed, arrives at a conclusion that the criteria of a valid patent are satisfied.
Have you got to add in some additional ingredient into your formula about giving a validating construction? I'm struggling towards it, but there is in my mind some idea that there must be a qualification, namely, even if you're otherwise right, only if the reason for the invalidity appears in the patent or would be apparent or reasonably apparent to a skilled person as part of the surrounding circumstances. I mean, if you came along and you have an ambiguous patent, it might cover an enormously wide scope, it might cover a narrow scope. You couldn't surely pop up later and say, it should be given the narrow meaning because actually I can show it doesn't work in this area, so it would invalidate it for lack of novelty if it covered that area. That can't be good enough, can it?
No, I would accept that, my lord.
So there must be some qualification somewhere. It must be, there must be something on the face of the patent which, I mean, in case of sufficiency, if the test of sufficiency is that it should be shown to be plausible across the whole width of the patent, and if the drafter of the patent deliberately or produces evidence of plausibility which only relates to one type of pain, then haven't you got an argument then that might satisfy my test? It would appear from the fact that he's focused or she's focused on one claim that the patent probably should be confined to that claim because that's all they've bothered to address.
But that is the limit of my submission.
Yeah.
My submission seeks to build on Mr. Mitchison's submissions yesterday that there is more than enough in the terms of the claims in this patent to justify a conclusion that it is valid, that it meets the tests of sufficiency.
Within a particular limit.
Yes, within the limits.
Because that's what they've been focusing
within the limits that Mr. Mitchison submitted. And all I am submitting is that if your lordships are left in doubt as to the proper construction of the claims, having heard Mr. Mitchison's submissions, then your lordships should lean, in my submission, in favour of upholding the patent rather than defeating it.
That's a wider submission than the one that you made in the previous sentence, isn't it? As I understood what you said before, you pressed your point no further than to say that one shouldn't go about looking for difficulties if on the face of the language they're not there to be found. You don't look for ambiguities. But then your last formulation suggests that you go further than that And in a case where there really is an ambiguity, you lean in favour of whatever construction would get it within the gateways.
Well, I'm making both submissions, my lord. I'm seeking to...
So you've got 2 points.
Well, yes, there are two different ways of putting the issue as to how your lordship should go about seeking to construe a patent. Now, if your lordships are of the view that Mr. Mitchison has the better arguments on claim construction, your lordship shouldn't look for ambiguities. If your lordships, however, are not persuaded by Mr. Mitchison that he's right on his construction, but rather that there is genuine ambiguity as to what the claims mean, then I do submit that your lordship should seek to uphold a patent rather than deciding the case against the construction.
Speaking purely for myself, I have no difficulty with the first proposition. I think the second one requires some scrutiny.
Well,
can I ask you something slightly related but slightly different? Both Lord Justice Sedley and Mr. Justice Newberger derived support for their completely contrasting approaches in the same statutory provision, Section 125,
yes.
subsection 1 of the 1977 Act. And I'm just looking at it, I wonder if it might actually be helpful for us to look at that.
Well, it's volume 17, isn't it?
Yes.
It's tab 202.
MS
the relevant
6958.
at 6958. MS 6958 in volume 17, tab 202, section 125, extent of invention. For the purposes of this Act, an invention for a patent for which an application has been made or for which a patent has been granted shall, unless the context otherwise requires, to be taken to be that specified in the claim of the specification of the application or patent, as the case may be, as interpreted by the description and any drawings contained in the specification, and the extent of the protection conferred by a patent or application should be determined accordingly. Hereby declared for the avoidance of doubt, where more than one patent is specified, each invention may have a different priority date. And then 3, the protocol and the interpretation of Article 69 of the EPC shall, as for the time being in force, apply for the purposes of subsection 1 as it applies to the purposes of that article. And Lord Justice Sedley founded a substantial part of his argument on Article 69 of the protocol.
Can we just see what the effect of subsection 1 would be in this case? I think it means you look at, unless the context otherwise requires, the invention is taken to be what we find specified in the claim, which is obviously the claim section, and we're looking particularly at claim 3, I suppose.
Yeah.
As interpreted by the description, which takes us to paragraph 6.
Yes.
And any drawings, which I don't think we're concerned with. So, for example, paragraph 3, we don't need to look at the summary.
Paragraph 6 does refer back to paragraph 3. Yes, it says as listed above in 6 in line 4.
Oh, yes.
But section 125 specifically requires its context to be understood by reference to the protocol, and the protocol is to be found.
Description, section 1251, is a statutory phrase which can't depend on the way in which a particular patent is drawn up. So, and as it also goes on to say, description, any drawings contained in the spec, I wonder whether, in fact, description doesn't include the summary of the invention anyway.
Includes the whole
Is
of
it-
the
is it
preambular
everything-
material.
Yes, it does. We would accept that.
Yes,
I see.
background, summary, and brief
Right.
description, yeah.
Yes.
Okay,
So it
that's,
includes everything.
that's,
Yes, we would accept that. The protocol is to be found in Authorities Volume 17 at 213 MS 7100.
One day we'll get away from MS, which now seems rather antediluvian. It ought to be E, shouldn't it?
Well, MS is memory stick, isn't it?
I know, but I mean, it should just be E,
Yes,
since
yes,
we're certainly not
yeah.
using memory sticks.
Absolutely. MS 7100, Article 1 of the Protocol, Article 69 should not be interpreted as meaning that the extent of the protection...
Sorry, which
conferred-
article are you reading from?
This is Volume 17, tab 213, MS 7100.
Right.
It's the Protocol which is mentioned in Section 125. Article 69 should not be interpreted as meaning that the extent of the protection conferred by a European patent is to be understood as that defined by the strict literal meaning of the wording used in the claims, the description and drawings being employed, only for the purpose of resolving an ambiguity found in the claims, nor should it be taken to mean that the claims serve only as a guideline, and that the actual protection conferred may extend to what, from a consideration of the descriptions and drawings by a person skilled in the art, the patent proprietor has contemplated. On the contrary, it is to be interpreted as defining a position between these extremes, which combines a fair protection for the patent proprietor with a reasonable degree of legal certainty for third parties. And indeed, in the appellate committee, Lord Hoffman, in the Kiran Amgen case, which is at volume 3, tab 28, if I could take your lordships to that. Volume 3, tab 28, at MS 2242, Volume 3, tab 28, MS 2242, at the bottom of the page, paragraph 30, his lordship said it seemed to his lordship clear that the protocol, with its reference to resolving an ambiguity, was intended to reject those artificial English rules for construction of patent claims. As it happens, though, by the time the protocol was signed, the English courts had already begun to abandon them, not only for patent claims, but for commercial documents generally. And he refers to Pren and Simmons and other well-known authorities. And therefore, there's a recognition that the construction of patent claims is analogous to the construction of contractual documents, and we would say deeds of settlement and indeed public law instruments.
Well, the real target of Article 69 and the Protocol, in addition to the corresponding provision of the Act, is the approach suggested in some of the older cases, that you simply take the claim
Yes.
on its own, out of the context of the rest of the patent, and construe it in isolation. And that is what they're trying to shoot down.
Yes, yes. And I'm submitting that one takes it a stage further, and one seeks to avoid creating ambiguity when there is none. And if there is ambiguity, well, then one adopts the approach that one adopts to a contractual document.
But how does the protocol assist your argument? You have to go further than the protocol.
Oh, yes, I don't suggest that the protocol provides an answer. I was simply responding to my Lord Reed's invitation to look at Section 125. I say one has to then look to the protocol, and then one looks to Lord Hoffman, who recognises that in this patent context, principles of contractual interpretation are also relevant. And it is well established in contractual interpretation, in the interpretation of deeds of settlement, that one does seek to adopt a validating principle. We do not accept that this in any way undermines legal certainty any more than it does in the field of contracts or in the field of settlements.
But in the context of a contract, you can understand the validity principle because the parties were intending to contract, so you want to enable them to have a legally binding obligation. Similarly, in a deed of settlement, the settlor is wanting to put a valid document in place. When you get to a patent, you're striking a balance between the reward of invention through a monopoly and the public interest in competition. I don't see at the moment why the more expansive form of your formulation, if the court finds ambiguity, it should seek to uphold the patent, is supported by anything you've shown me so far.
Yes. My submission is that equally in the patent context, the patentee is seeking to arrive at a valid instrument. That's why the patentee presents the patent. The position
It's not the court giving a bonus, it's the court giving effect, you say, to the intention of the patentee.
Precisely. And I say that this principle is not only seen in private law, it's seen in public law, where the court will seek to construe an ambiguous regulation or other public law instrument so as to secure its validity. If one looks at Raymond and Honey, for example.
The patentee has two inconsistent desires, doesn't he? The patentee wants the widest possible monopoly, so he's going to push the frontiers out as far as he can, consistently with the desire not to have an invalid patent. And the books are absolutely full of cases where patentees have got that very difficult judgment wrong.
The contracting party may have competing considerations. The contracting party wishes to arrive at terms of a contract that best advantage him without falling foul.
But the one thing you can assume about parties to a bilateral agreement is that they both want their agreement to be valid.
Well, to which my answer is that where one has a unilateral instrument, whether it is a deed of settlement or whether it is a public law instrument, equally the promoter of that instrument wishes to secure something that is valid. If we could just look at Raymond and Honey, which is the public law case, Authorities Volume 4, tab 43, one sees this principle in the appellate committees. MS page 2930. And if your lordships would look in Raymond and Honey at page MS 2941, the context here at page 12, letter G, is the stopping by the appellant, the prison governor, of the prisoner's application to the High Court. And Lord Wilberforce, speaking for the appellate committee at letter H, says, in his opinion, there's nothing in the Prison Act that confers power to make regulations that would deny or interfere with the right of the prisoner to have unimpeded access to a court. Section 47 is a section concerned with the regulation and management of prisons. In his lordship's opinion, it's quite insufficient to authorise hindrance or interference with so basic a right. The regulations must be interpreted accordingly, otherwise they would be ultra vires. In other words, as a matter of public law, the court will seek to interpret an instrument to secure its validity rather than arrive at a conclusion that it is invalid. We respectfully submit that there are close analogies in relation both to deeds of settlement, public law instruments, and indeed other instruments which justify the application of a validating principle in the present context as in these other contexts. Indeed, my Lord, Lord Reid, applied the validating principle in the public law context in your lordship's dissenting judgment in the Mohammed case relating to a United Nations instrument. So there is ample authority for applying this principle outside the context of bilateral relationships. Your Lordships will have seen that there are many cases from other jurisdictions to which we have referred where a validating principle is applied in order even to resolve an ambiguity. And we've set out those cases in our printed case at paragraphs 169 to 174. We refer to case law in the United States, Australia and Canada. And I don't have time to go to those, but we commend those authorities to the court.
Well, Panning, is there a possible distinction between the sort of exercise that Lord Wilberforce was undertaking, where he said, well, you look to the primary legislation, and it's quite obvious that if you interpret it that broadly, it's going to be ultra vires, and the present situation where this isn't something that jumps off the page. This is something that only emerges after a lengthy trial and appeal, which establishes, after hearing expert evidence all round, that there's nothing here that provides plausibility in relation to central neuropathic pain. In other words, it's not an exercise of construction that one can do just with the documents. One needs a great deal further help before it even begins to dawn. And if the proceedings had been about infringement rather than validity, and the alleged infringement was the use for central neuropathic pain, the principle might be sought to be applied in exactly the opposite way.
Yes. Well, your Lordship is, of course, correct that the context in which the issue may arise may depend upon a detailed examination of facts, but that may be true in the public law context as well as to the application of the particular public law instrument. And I would respectfully submit the extent to which the validating principle is applicable in the patent context cannot depend upon the distinction that your Lordship draws attention to. If you mind my answer. Lords, that's what I wanted to say on the validating principle. Can I turn to my second topic, which is abuse of process? If the court were to uphold the judge's findings on invalidity, then it would be necessary to consider whether Mr. Justice Arnold and the Court of Appeal were correct to deny the appellant the opportunity to seek to amend Claim 3 so as to limit the claim to the subject matter which the judge held was both inventive and sufficient, that is, in relation to peripheral neuropathic pain. Mr. Justice Arnold addressed insufficiency in this respect, starting at paragraph 339. Your Lordships would go to Core Volume 3 at MS 812. Your Lordships will see at the top of page 812 the subject of insufficiency is then addressed, and the relevant paragraph for present purposes is at MS 815, paragraph 351, where his Lordship turns to peripheral neuropathic pain, and his Lordship found that the evidence is finely balanced, and if one goes down some 6 lines, nevertheless I have concluded on balance that given that plausibility is a relatively low threshold, the data contained in the specification, when read with common general knowledge, just makes it plausible that pregabalin would be effective to treat peripheral neuropathic pain. And then he gives some detail. And at 352, given that Claim 3 is not restricted to peripheral neuropathic pain, and there's no application to amend it so as to restrict it in that way, however, this conclusion does not save the validity of Claim 3. So that's the basis on which his Lordship dealt with peripheral neuropathic pain. That judgment was handed down on the 10th of September of 2015, and on the 1st of October, the appellants applied to amend Claim 3 to confine it to peripheral neuropathic pain. And that led to the post-trial judgment of Mr. Justice Arnold, dated the 25th of November 2015, which is Core Volume 3, MS 886, where his lordship dismissed the application to amend as an abuse of process. And his lordship dismissed it because, I summarise, the amendment could have been sought in the alternative before the trial began, and in his lordship's view, there would need to be a further hearing which would occupy between 1 and 2 days to allow the respondents to raise points on the clarity and the sufficiency of the amended claim. And his lordship said that's an abuse of process to seek to amend at this stage. The Court of Appeal dismissed the appeal on this point at paragraphs 174 to 183, Core Volume 3, MS 587. I'll just give your lordships the reference. We take 3 points in relation to abuse of process. We say that the trial judge and the Court of Appeal erred in law for 3 reasons. First of all, we say that Section 75 of the Act, read with Article 138 of the EPC, confers a right to seek to amend in the light of the judgment of the trial judge. Secondly, we rely on Section 63 of the 1977 Act. We say the patent has been found to be partially valid. And thirdly, we say that it was disproportionate to refuse to allow us to seek an amendment, given the findings of the judge, and given that any detriment to the respondents by reason of the need for a further hearing could have been addressed, should have been addressed by appropriate orders for costs.
The logical order is slightly different, isn't it? Isn't the partial validity logically the first?
It may well be, but can I deal with them in that order, my lords? The first one is Section 75 of the Patents Act. Your lordships find that in Volume 17, tab 202, MS 6955. Volume 17, tab 202, MS 6955, Section 75, in any proceedings before the court in which the validity of a patent may be put in issue, the court may allow the proprietor of the patent to amend the specification of the patent in such manner, subject to such terms as to advertising, as to costs, expenses, or otherwise as the court thinks fit. And in subsection 5, in considering whether or not to allow an amendment proposed under this section, the court shall have regard to any relevant principles applicable under the EPC. And section 75.5 was added with effect from the date 13th of December 2007, when the EPC was amended. The EPC 2000 made substantial amendments to the EPC, and in particular, for our purposes, Article 138 was amended, and Article 138 can be found at tab 212 of the same volume, MS 7098, Article 138, revocation of European patents, subclause 1, subject to Article 139, a European patent may be revoked with effect for a contracting state on various grounds, and then subclause 3 over the page, 7099, at the top of 7099, in proceedings before the competent court or authority relating to the validity of the European patent, the proprietor of the patent shall have the right to limit the patent by amending the claims. The patent as thus limited shall form the basis for the proceedings. And previously, Article 138, we can see the previous version in the previous tab, which is 211, tab 211, MS 7082. This is the old version of Article 138. Article 1382, if the grounds for revocation only affect the European patent in part, revocation should be pronounced in the form of a corresponding limitation to said patent. If the national law so allows, the limitation may be effected in the form of an amendment to the claims, the description, or the drawing. So previously, matters were left to national law, and Article 1383 now confers a right to limit the patent by amending the claims. And the question is the extent of that right.
I mean, 138 sub 3 tends to suggest that it's envisaged that the amendment will be made before or at the outset of the proceedings, does it not?
Well, that's not, in our submission, the way in which the EPC has been applied. And if one looks at the guidelines for examination in opposition proceedings, one sees that. It's in volume 18 of the materials. And if your lordships please would go to tab 221, your lordships will see guidelines for examination in the European Patent Office.
Have you got a page number for us?
7245.
Thank you.
My lord. MS 7245. These are part of the guidelines, and we're looking at paragraph 2.2, examples concerning oral proceedings in opposition procedure. And we're told if oral proceedings are arranged, the opposition division issues a summons together with an annex, drawing attention to the points to be discussed, and normally containing the division's provisional and non-binding opinion. The following situations may arise. In situation A, we draw attention to the last three lines. If, during the oral proceedings, the opposition division, contrary to its provisional opinion set out in the annex to the summons, reaches the conclusion that the patent should be revoked, a request of the proprietor for further amendment should be admitted into the proceedings. B, if the opposition division states in the annex to the summons that the patent is likely to be revoked, requests for amendment should be admitted if they are filed before the final date fixed under the rule. Now that strongly suggests that the procedure under the EPC is that it is only when the patentee is informed of the division's provisional or concluded view as to invalidity that the obligation to amend arises. Until that time, and until a reasonable period after that time, the patentee has the right to seek to amend.
What is the date fixed under Rule 116?
Under Rule 116, we have Rule 116, we have copies of Rule 116. When issuing the summons, the EPC shall draw attention to the points which in its opinion need to be discussed for the purposes of the decision to be taken. At the same time, a final date for making written submissions shall be fixed. New facts and evidence presented after that date shall not be considered. So it doesn't actually specify a date, it requires a date to be fixed.
Well, that doesn't, but if you look at the cross-reference under 22B, that suggests that you've got to apply to amend before the date fixed under 116 for submissions. So in other words...
In a normal case.
What?
In a normal case.
Yes.
Yes, but that is subject, in my submission, to the right of the patentee to have an opportunity to seek to amend once it has been informed of the division's view as to invalidity.
I mean, there's a world of difference between the opposition division's provisional view and the final decision of the tribunal. And the equivalent here is the final decision of the tribunal, isn't it?
But the scheme of the EPC is to allow the patentee the opportunity to amend up until the time that it has been informed of the authority's provisional or final view as to the invalidity of the patent. And that is how other states have operated these principles.
Can I just get the procedure clear? As I understand it, the procedure in the opposition division is essentially an administrative proceeding.
Yes.
If you don't like the result, you go to the Technical Board of Appeal.
Yes, indeed.
Which is a judicial proceeding, adversarial. And clearly this procedure will result in an amendment application having been made before it goes before the TBA. Or am I wrong about that?
No, Your Lordship is correct that it is an administrative procedure, but we say the analogy under our system is that there is no official determination of invalidity until the High Court judge makes his decision. And for the purposes of applying an analogy with Article 138, we say that we must have the opportunity to seek to amend once that decision is made. And we rely on the way in which these provisions have been interpreted and applied.
Is it not also consistent with what we read in the passage you've taken us to? If the Rule 116 date is significant in a situation where you have been warned effectively
Yes.
by the opposition division in the annex to the summons,
Yes.
the patent is likely to be revoked. In that situation, you're supposed to make your application for amendment before the final date for submissions.
Yes.
But if you haven't had that warning, the final date for submissions passes, you then have the oral phase
Yes.
of the procedure, and the paragraph that you took us to at the foot of MS 7245 tells us that if during the oral proceedings the opposition division, contrary to its original opinion in the annex of the summons, reaches a conclusion that the patent should be revoked, then at that stage you can make a request for amendment.
That's my submission. It's only when you have some form of official statement, whether it's provisional or otherwise, that your patent is invalid, that the time begins to run for the purposes of amendment. And one can argue about how long you should have thereafter. But what we say is inconsistent with these principles is for the domestic courts to adopt the approach that once the judge has decided the case, has declared invalidity, you are in principle too late. That is simply inconsistent, and it's inconsistent in my submission with the way in which other European jurisdictions have applied these principles. The respondents draw attention in their reply case to a very recent decision of the Supreme Court of the Netherlands, and one finds that decision in volume 12 of the authorities at tab 142. It's the High Point SARL case. And they rely on paragraph 4.17, which is at MS 5567, volume 12, tab 142, MS 5567. This is the judgment of the Supreme Court of the Netherlands. And my friends draw attention.
Could I just ask clarification? That's presumably the Cour de Cassation. Is it?
It's the Hohe
Is
Raad.
it called- Oh, I beg your pardon. I think
It's the Hohe Raad.
Yes, I'm in Belgium.
And at 4.17, at the bottom of MS 5567, lastly, it's important that it's accepted in other contracting states that the right enshrined in Article 1383 to limit a patent in national proceedings on the validity of the European patent is subject to procedural requirements under national law. And we accept that. There's no dispute that that is so. But there's then a reference, see the opinion of the Advocate General at paragraph 420. And if the court please will turn back to the previous tab, which is tab 141, which begins at MS 5532, the passage to which the Supreme Court of the Netherlands referred includes paragraph 4.23, which is MS 5548, where the Advocate General at 4.23 on MS 5548, according to case law of the German courts, the submission of new auxiliary requests on appeal is in principle not allowed if the preliminary ruling gave cause to already submit the auxiliary requests at first instance, and the patent proprietor inexcusably failed to do so. In that event, the auxiliary requests are not qualified as referred to in the relevant law. If the court did not give any preliminary ruling at first instance, did not do so in a timely fashion, or did so incompletely, as a result of which the patent proprietor was unable to already apply to that at first instance by limiting the patent, then generally speaking, the patent proprietor is allowed to first limit the patent during the appeal. So again, one sees an approach that it's only when the court has told you your patent is invalid that time begins to run for the purposes of invalidity. The German approach to these matters can be seen in the same volume, volume 12, at tab 140. If please the court would turn back to tab 140. This is a judgment dated 2009. Sorry, I'm looking at a Dutch case, the Supreme Court of the Netherlands. The German case, I'm sorry, it's 140.
This is the German case.
MS 5519. This is the German decision. Yes, this is a judgment of 21st of June 2016, and the relevant passage in that can be found at paragraphs 42 to 44, which is MS page 5525. Paragraph 42, it was only at the hearing that the defendant learnt from the Patent Court that as a result of the supplementary submissions of the plaintiff, it, that's the Patent Court, had moved away from its preliminary opinion expressed in the notification. This information was the first occasion the defendant had to examine whether and possibly in what form it might consider a defence of the patent in suit in a more restricted form. The defendant then stated that it wished to defend the patent in the form of several restricted auxiliary requests, albeit at that point in time not yet the versions on which the patent was defended according to auxiliary requests 1 to 3. This fact does not preclude the expediency of those requests. 43. When assessing the question of whether and possibly in what form a limited defence of the patent in suit in amended form might be suitable, complex considerations come into play with regard to the admissibility of such a defence and its prospects of success. As a result, there are compelling reasons not to charge the patent proprietor with neglecting his duty to expedite proceedings if he is unable to complete his deliberations during the hearing before the patent court. This particularly applies if, as in the present case, it cannot be derived from the minutes of the oral proceedings whether the patent court made clear the specific reasons it had for changing its preliminary opinion, thus providing the patent proprietor with a clear indication of what limitations might be expedient in order to take account of the concerns of the court. And so the auxiliary requests were thus admissible. So we do say that there's clear authority from Germany and the Netherlands that there is a right in the patentee to amend its claim, albeit at a late stage, if it has not previously been informed by the judicial authorities of the invalidity of its patent. And of course that does not occur in this jurisdiction until Mr. Justice Arnold hands down his decision. And we therefore do submit that seeking to apply Section 75 consistently with the EPC, see Section 75.5, your Lordship should arrive at the conclusion that to say it is an abusive process for the appellants to seek to amend after the judgment of Mr. Justice Arnold, is not consistent with the EPC and the practice under it, as evidenced by other states. That's the first way we put the abuse of process point. The second way that we put the abuse of process point is by reference to Section 63 of the 1977 Act. And Section 63 can be found in volume 17 of the authorities, tab 212 at MS7 6950, tab 202, section 63, MS 6950, relief for infringement of partially valid patent. If the validity of a patent is put in issue, tab 202, my lord, MS 6950.
Yes, I've got it, yes.
Relief for section 63. If the validity of a patent is put in issue in proceedings for infringement of the patent, and it's found that the patent is only partially valid, the court may, subject to subsection 2, grant relief in respect of that part of the patent which is found to be valid and infringed. And then there's provisions as to damages and costs. And subsection 3, as a condition of relief under this section, the court may direct that the specification of the patent shall be amended to its or his satisfaction upon an application made for that purpose under section 75 below. So Parliament has recognised that section 75 may have application after the finding of the court as to validity, if it's a finding as to partial validity. And we rely upon the approach that was adopted by Lord Justice Floyd for the Court of Appeal. If we go back, please, to Core Volume Part 3, MS 588. This is the judgment of the Court of Appeal, Core Volume 3, MS 588, paragraph 175. It's the sentence, the second sentence, where His Lordship for the Court of Appeal said he had difficulty in distinguishing this case from a notional law in which Claim 3A was to neuropathic pain generally and Claim 3B is to peripheral neuropathic pain. And our submission is that on the findings of Mr. Justice Arnold, there is a finding that the patent is partially valid in the sense that validity is established on the material before His Lordship as to Claim 3B, as to peripheral neuropathic pain. And we submit that it cannot be an abuse of process to invite the court, pursuant to Section 63, which then refers to Section 75(5), to invite the court to uphold the partially valid part of the claim. We recognise, of course, that the respondents seek to challenge the findings of Mr. Justice Arnold as to validity. They wish to make further points as to clarity and as to sufficiency. And Mr. Justice Arnold held that they are entitled to do so. In my submission, however, the respondents cannot seek to defeat, for the purposes of Section 63, what is a finding of validity by taking objections which we will submit at a further hearing are unfounded objections. So we say that Section 63 applies. The third and final way we put...
Could I ask one question?
Of course.
Does the gateway to Section 63 depend on the claim in particular, the Claim 3, being partially valid? Or is this a patent which in any way is partially valid because other claims remain held to be valid?
Well, Your Lordship is certainly right that other claims were held to be valid by Mr. Justice Arnold.
Yes.
And I take Your Lordship's point that that would be sufficient in itself. I've focused on the approach to Claim 3 and the finding made by Mr. Justice Arnold that in effect one has 3A and 3B. But Your Lordship's absolutely right.
Yes.
Of course, there were findings which are challenged on the cross-appeal, but findings by the lower courts that there were valid claims in any event. And so we would respectfully adopt that point.
But they're not good enough, Phil. I mean, they're too narrow.
They are, but the point, as I understand it, that's being put to me by my Lord Hodge, is that the claim was held to be partially valid, and that must be relevant.
Well,
to
the
whether
patent was held to be partially
the patent was
Claim
held to be
3,
partially.
surely, to say that Claim 3 has been held to be partially valid depends on it being severable into valid and invalid parts. And that's where the problem arises, is on the face of it, it's not severable, it's simply too wide.
No. Well, it's severable if one understands Claim 3 to fall into two parts, as Lord Justice Floyd for the Court of Appeal was prepared to accept. Once one...
It's a very unusual approach to severability.
In my submission, it is a permissible approach given the objective, the statutory objective of Section 63, which is, in my submission, to save that which is savable and to protect those opposing the patent by reference to statutory provisions which protect their interests. If your Lordships would go back, please, to Volume 17, tab 202. Your Lordships have already seen that under Section 63(2), this is MS 6950, the Court has a wide discretion as to costs or expenses. But your lordships will also wish to note at 6950, section 62, subsection 3, where an amendment of the specification has been allowed under any of the provisions of this Act, the court, when awarding damages or making an order for an account of profits in proceedings for infringement committed before the decision to allow the amendment, shall take into account a number of factors, whether the defendant knew or had reasonable grounds to know that he was infringing, whether the specification was framed in good faith and with reasonable skill and knowledge, and whether the proceedings are brought in good faith. So the Parliament has recognised that it is necessary to protect other interests and has done so by those provisions. My Lords, finally on abuse of process, we say in the very unusual circumstances of this case, the lower court should have recognised that it is disproportionate to prevent the appellants from seeking to amend the claim in the light of the findings made by Mr. Justice Arnold. The circumstances are set out by the Court of Appeal in Core Volume Part 3, Paragraph 177, which is MS 588. Well, pick it up at 176. It's tempting to think that this is MS 588. It's tempting to think it's not the absence of an application to amend which is at the root of the alleged unfairness to Mylan and activists. If they have a complaint about the issue of sufficiency, it has to be based on the fact that the construction advanced by Warner-Lambert was raised very late, after that the judge cannot have regarded it as procedurally unfair for Warner-Lambert to run their construction argument. Mylan and activists did not suggest it was not open to Warner-Lambert. The judge ruled on it, and he ruled on the sufficiency of a claim so construed. The judge then says that fairness requires that Mylan and activists have another opportunity to run their clarity point and their sufficiency point in relation to amended claim 3. And in my submission, the proper way to address the competing interests is to, of course, allow the respondents a further opportunity to make any points they wish to make. The judge concluded that this would take a day to 2 days of further argument, and it may well be appropriate to order the appellant to pay the costs of that. But it's a very harsh detriment on the patentee, and it confers a windfall advantage on generic companies, not just the respondents but others, for the appellant to lose patent rights to the treatment of peripheral neuropathic pain, even though the judge has found, and I showed your lordships the passage, he's found that part of the claim to be both novel and sufficient. And we therefore submit that in principle, in the exceptional circumstances of this case, the only fair answer was to allow the appellant to seek to amend for the further hearing to take place, and if appropriate for us to have to pay the costs incurred.
So you don't run the issue estoppel point?
No, I'm not pursuing that. My Lords, that's what I wanted to say on abuse of process. Can I turn to infringement?
Just before you do,
Yes, of course.
we were looking at the case of the High Point case.
Yes.
In the Netherlands, and you referred us to the statement at paragraph, I think 4.7.1.7 in the judgment. 5567 is is the MS. That this right to amend is subject to the dictates of national law.
Yes.
And you, I think, said you accepted that.
Yes, I accept that it cannot be open season. It must be open to the national court to say that it is an abusive process because you're too late in seeking to amend.
And then you referred us to the AG's opinion, but the paragraphs to which the judgment refers in the AG's opinion extend right through to the description of this very case, do they not?
They do extend. There's a number of paragraphs, but I'm focusing on a recognition in the Advocate General's opinion, as approved by the court, that the patentee must have the opportunity.
Well, in Germany, but the court itself, the Hochrat order, I'm not sure my pronunciation is right, in talking about the dictates of national law, is looking not merely at German law but English law, and it's a much more restrictive, on your submissions, regime in England.
Well, it's recognising the approach taken in English law, but my point is that both in Dutch law and in German law, there is a recognition that a right to amend must exist from the date, reasonable date, from when the judicial authorities tell the patentee that its patent is invalid.
So your concession is only that some dictates of national law are relevant, but not all of them?
No, my submission is that the domestic court must have a power to prevent an abusive process by reason of a delayed application to amend. My submission is that in principle, it cannot be an abusive process for the patentee to seek to amend within a reasonable time from when the judicial authorities tell it that its patent is invalid. That's the point I'm seeking to make. Otherwise, I accept, of course, national procedural rules must be applicable. And I say in this case that is the circumstance, that we are told you're too late, even though we seek to amend within a reasonable time, indeed within 2 or 3 weeks, of the judicial authorities telling us that our patent is invalid. My Lords, our case on infringement of this Swiss form claim for second medical use is based on these propositions. First, we respectfully agree with the statement at the beginning of the respondent's written case. It's paragraph 1. I don't ask your Lordships to turn it up, but it's core volume 2, MS 258, that Swiss form claims are exceptional. And they're exceptional, as your Lordships know, because there's nothing new about the product. There's nothing new about its method of manufacture. There's nothing new about its means of administration. Nor, under patent law, can the originator rely on a new method of treatment of an illness, because Section 4A of the Act precludes reliance on such a matter. My Lord Reid is...
I thought it was slightly narrower than that.
Well, can I... let me be accurate. Let me go to Authorities, Volume 17, tab 202, at 6945. Section 4A of the Act, Volume 17, tab 202, MS 6945, methods of treatment or diagnosis. A patent shall not be granted for the invention of A method of treatment of the human or animal body by surgery or therapy, or B, a method of diagnosis practiced on the human or animal body. Subsection 1 does not apply to an invention consisting of a substance or composition for use in any such methods. That's the point your Lordship was making. I accept that. But on any view, this is an exceptional claim. Secondly, nevertheless, there's no dispute between the parties that the law recognises that there are strong public policy reasons to recognise second medical use claims. And the public policy reasons were summarised by Mr. Justice Arnold, if I could take your Lordships, please, to Core Volume 3, MS 750, and it's paragraph 88 of his Lordship's judgment. Core Volume 3, MS 750, paragraph 88 puts the point well. It's increasingly been recognised, says Mr. Justice Arnold. Core Volume 3, my Lord, MS 750. and it's paragraph 88. It's increasingly been recognised over the past 30 years or so. It's important to find new uses for existing medicines. Existing medicines have the advantage they're known compounds, they're shown to have acceptable safety profiles, they need much less testing. Experience shows a compound that has therapeutic benefit in one application not infrequently turns out to have therapeutic benefit in another application, sometimes more than one other application, which may be quite different to the first. Thus, there is significant potential and value in finding such second and third, etc., medical uses. Discovering such second medical uses requires difficult, expensive research, however. How is the research to be funded? The answer provided by the European patent system is to grant patents for second and subsequent medical use of known compounds. The monopoly conferred on the inventor who finds the second medical use provides the return on the investment required to fund the research. So that's, in essence, the public policy consideration, and it's a very important one. And it's emphasised in the written representations that the court will have seen from the interveners, the ABPI, Core Volume 2, MS 509, and the EFPIA, which is Core Volume 2, MS 496. And I won't take time on that, I don't have time to take on that, but they set out the public policy considerations. That's the second point. The third point is that a solution to the legal problem of how to protect second medical use innovation was pioneered by the Swiss Patent Office, and the statement of facts and issues in this case sets out, if your lordships have Core Volume 1, the Statement of Facts and Issues, MS 107, Core Volume 1, MS 107, it's paragraph 9, Swiss form claims Swiss form claims seek to avoid the legal difficulties by framing the claims as use of substance X for the preparation of a medicament or pharmaceutical composition for treating indication Y. That's the Swiss form claim. And we all agree that for, in the phrase for treating, means for the purpose of. It doesn't mean suitable for, it means for the purpose of. I should mention, your lordships will have seen, that the EPC has been amended, Article 54.5, so it now allows for the grant of a purpose-limited product claim. This is a process claim, the Swiss form claim. It's now been amended, the EPC, to allow for the grant of a purpose-limited product claim. And after the 28th of January 2011, no new applications were allowed under the EPC to include Swiss form process claims, but we're not concerned with that innovation, with that change. The proper interpretation and application of Article 54.5 is for another day, and the material before the court makes it very clear that Swiss form claims will continue to be of very considerable practical importance for many years to come.
Where do we find Article 54.5?
Your Lordship finds it in volume 17 behind tab 212. This is the new version, MS 7086. We're told under the heading of novelty, subparagraph 5, paragraphs 2 and 3 shall also not exclude the patentability of any substance or composition referred to in paragraph 4 for any specific use in a method referred to in Article 53C, provided that such use is not comprised in the state of the art. And that's
now just patent the use.
Yes.
As an exception.
Yes, yes. It's not a process claim, it's a product use claim. But we're not concerned with that, your Lordship appreciates. We're concerned with the Swiss form process claim. So that's the third point. The fourth point I emphasise is that we, of course, accept there is a competing public and private interest. And the competing public and private interest is in ensuring that Swiss form claims do not undermine the legality of the manufacture, the supply, the use of the product for non-patented indications, that is, indications for which the original patent has expired. There's a public and private interest in competition, in lowering prices, in increasing public access to medicines. We accept that, of course. And fifthly, by reason of that...
And it may be said that that was, in a sense, the real quid pro quo and purpose of the original patent, the patent for the first use.
For the first indications, indeed. And the difficulty in this case, of course, is one has a new patent with new indications. And that's why, fifthly, we submit...
I think all I'm suggesting is that the public interest goes a little further than just a competing public interest. It's one which arises out of the patent system itself.
Yes, I accept that. The quid pro quo of the original grant of the patent was that after the 20 years, others would be able to use the art in order to provide the product for what were patented indications and are no longer patented indications. I accept that. And fifthly, in the context of infringement, as in other contexts, patent law inherently involves here a search for a fair balance between these various interests. And the respondents make that point, paragraph 3 of their written case. We made it in our written case. It's a search for a fair balance. The sixth point we make is that because Swiss form claims recognise a patent by reference to manufacture for a novel purpose, even though there's no novelty in the product itself, there's no novelty in the method of manufacture, the law governing infringement of such claims presents challenges to traditional patent law, if I may say so, to traditional patent lawyers. And the respondents recognise this point, they recognise this point at paragraph 54 of their written case. Could I take your lordships back to core volume 3, so core volume 2, at MS 275, paragraph 54, where this is the respondent's written case, core volume 2, MS 275, paragraph 54, accordingly, the language of the claim does not naturally fit with established patent law principles. The product is the same, and following conventional principles, the patent claim does not exclude the manufacture of the old medicament, in fact, the very same medicament, when the only use that was known for it was the old use. And then they refer the respondents to what Mr. Justice Arnold said. His lordship described these Swiss form claims, therefore, as a judicial fudge. And the Court of Appeal in the interlocutory judgment used the same phrase. For your lordship's note, it was Mr. Justice Arnold at paragraph 90 of his judgment, core volume 3, MS 751, and the Court of Appeal in the interim injunction judgment at paragraph 53 also referred to Swiss form claims as a fudge, core volume 3, MS 695, and the respondents, reading on in their written case, the next page, MS 276, they say, paragraph 57, because they're a fudge, they lead to difficulties both as to principle and as a matter of practicalities. And these difficulties cannot be solved by resort to the EPC, because under the EPC, infringement is dealt with by national law. That's Article 64, paragraph 3. Its authorities, volume 17, tab 212, MS 7089, Article 64.3 of the EPC. Any infringement of a European patent shall be dealt with by national law, at least until the European Unitary Patents Court is given birth to. So that's the fair balance point. The seventh point is that the Swiss form claim poses particular difficulties in the application of the statutory test for infringement under Section 60, both Section 61 and 60 subsection 2. And that's because a Swiss form claim, as I've indicated, and as is not in dispute, concerns the process of manufacture for a specified purpose. In other words, for in the sense not of suitable for, but for the purpose of. And the difficulty is that if one goes to the statutory provisions on infringement, volume 17, could I take your lordships to volume 17 at tab 202, one sees the limited role for a mental element in MS 6947, the limited role of a mental element in the relevant provisions of the statute. Section 60 deals with meaning of infringement. Section 61 is direct infringement. Section 62 is indirect. And if we look under 61, we are concerned here, we all agree, with 61C. There is infringement where the invention is a process, which it is. He disposes of, offers to dispose of, uses or imports any product obtained directly by means of that process, or keeps any such product, whether for disposal or otherwise. And there is no mental element at all in the definition of direct infringement. By contrast, in section 61B, where the invention is a process, he uses the process or he offers it for use in the UK when he knows, or it's obvious to a reasonable person, that its use without the consent of the proprietor would be an infringement. That's a mental element only of knowledge, not of intention. Section 62, indirect, subject to the following provisions of the section, a person other than the proprietor also infringes a patent for an invention if, while the patent is in force and without the consent of the proprietor, he supplies or offers to supply in the UK a person other than the licensee or other person entitled to work the invention with any of the means relating to an essential element of the invention for putting the invention into effect when he knows, again a test of knowledge, or it's obvious to the reasonable person in the circumstances that the means are suitable for putting and are intended to put the invention into effect. And as I shall show you, lordships, the reference at the end to intention is not the intention of the infringer, it's the intention of the end user. So the difficulty is that Section 60 does not include a test of intention. The only mental element relates to knowledge. And this problem was identified, your lordships may just wish to look at this, by Lord Hoffman in 1996 in the Merrill Dow case. It's Authorities Volume 14, and it's tab 161, and it's MS 6010. This is Merrill Dow against H.N. Norton, Volume 14, tab 161, and I'm looking at MS 6010. This is the grant of a patent for a new purpose in a non-medical context. And Lord Hoffman at page MS 6010 is referring as he says at line 8, the reference to non-medical purposes because patents for a second use of medical products give rise to certain special problems under the EPC. And if I pick it up at line 30, he's referred to the Enlarged Board of Appeals decision in the case that he's considering, the Mobile case. He says, I think it fair to say, in the UK at least, this is line 30, this aspect of the Enlarged Board's decision has been criticised on the ground that a patent for an old product used in an old way for a new purpose makes it difficult to apply the traditional UK doctrine of infringement. Liability for infringement is absolute. It depends upon whether the act in question falls within the claims. It pays no attention to the alleged infringer's state of mind. But this doctrine may be difficult to apply to a patent for the use of a known substance in a known way for a new purpose. How does one tell whether the person putting the additive into his machine is legitimately using it to inhibit rust or infringing it to reduce friction? In this appeal, however, we are not concerned with this aspect of the case. Today, of course, we are concerned with this problem, but that is the problem.
What is the basis for claiming that the use of a compound for a particular non-medical purpose was patented or could infringe?
Because the Technical Board of Appeal recognised that that was so. That is the Mobile case, and it's the passage at the top of 6010.
Is it a second use case, or what is
Yes,
it?
yes.
It's a second use case. But I thought
It's non-medical,
yes.
and therefore the problems with which we are concerned.
Yes, because
to-
there's no
to-
prohibition on
Yes.
patenting for
Yes.
use.
Yes. Now, my lords, it's common ground in the present case in relation to Swiss form claims that when infringement is addressed, some mental element is necessary. One can only make this system work. One can only reconcile, or at least have a fair balance between the competing interests, if one incorporates something more than is expressly set out in section 60.
Why does it have to be a mental element for something more?
Well, it has to be something that recognises that the Swiss form claim is designed to protect the use of the product for a particular purpose.
But one possible way of doing that would simply be to say that the duty of the generic manufacturer is simply to identify the indications for which the drug is intended, in the objective sense of that word, on the patient information leaflet, the label, the other material supplied and for the most part required to be supplied with the product. That would not involve any mental elements. It would be a purely objective question.
But unfortunately, it doesn't prevent the use of their product for patented indications.
Nothing will do that, short of your particular submission that foreseeability is enough. But I'm simply questioning your notion that you have to go to a mental element in order to give effect, in order to deal with the well-known problems involving Swiss form patents. One way of dealing with the question, it wouldn't be totally effective, relatively restrictive duty, which I've mentioned. I can see why that's not good enough for you, but one may have to put up in this field with something less than total security.
Well, it's not putting up with less than total security, it's putting up with the use in practice of the product for patented indications without any remedy for us, which defeats, in my submission, the whole purpose of the Swiss form claim.
All the various solutions canvassed or almost all various solutions canvassed are incomplete.
There is no perfect solution.
The only way that you can ensure that the drug is never used for a patented indication by a non-licensed manufacturer is to say that all uses of the product which carry any more than de minimis risk of use for a patented indication are infringing.
Yes,
Now, that is your preferred solution.
it is.
If one stops short of that and accepts that one may have to accept a situation in balancing the interests of the various parties involved, which involves less than total security for your clients, then it seems to me that one possible solution is the one that I've indicated. Yeah. The problem about your solution is it involves no balance between the relevant interests at all, but converts into infringers everybody involved, even those involved in perfectly good faith.
But the whole point of patent law is that it is strict liability. That's why I showed your lordships the provisions. And we are seeking to persuade the court to adopt an approach in the context of the Swiss form claim that is best reconcilable with the scheme of Section 60 in terms of the ingredients of infringement.
Because it's strict liability, doesn't one have to be rather careful in defining what the liability is?
Just remind me where Section 60 is.
Yes, my lord. It's volume 17. It's tab 202, and it's MS 6947. And if one just looks at the wording of Section 61C, where the invention is a process, well, it is here, we agree, he disposes of, offers to dispose of, uses or imports any product obtained directly by means of that process, or keeps any such product, whether for disposal or otherwise. That's the terms of infringement. And I'll come to indirect infringement in due course. And I respectfully submit that the solution that's being suggested to me for the purposes of argument by my Lord Sumption is one that frustrates the purpose of Section 61C and indeed frustrates the purpose of the Swiss form claim that we are...
I mean, isn't the problem that really you want to amend the law which prevents you taking out a patent for treatment of humans by a product, or the use of a product. The Swiss form claim is a no doubt understandable concession to the desirability of second use, new second uses being discovered, but you can't have the whole of your cake, at least.
No, but there's no point in recognising the concession, as your lordship puts it to me, unless it sounds in an effective remedy.
Maybe it sounds in a sort of quasi-effective remedy, a remedy which is moderately effective.
I mean, the difficulty in this case is that in practical terms, prescribing and dispensing practice means that the solution put to me by my Lord Sumption doesn't work. And if we look at...
Would work if prescribers were absolutely rigorous in only prescribing by brand name for pain. The problem about your submission, and I see the logic of your submission, is that it achieves a huge overkill. It essentially makes large numbers of people involved in the handling and manufacture of lawful generic products liable on account of what they suspect may well happen elsewhere, in the pharmacist's office, in the doctor's surgery.
Let me deal
That
with
seems
those,
a surprising result.
well, let me deal with those two separate points, because they are separate points. Your Lordship's first point to me was that the solution is for doctors to prescribe. Might be for doctors to prescribe by reference to the branded product in circumstances where they are prescribing for the patented indication, pain, or whatever it is. The answer to that isn't what they do. And the statement of facts and issues, paragraphs 45 to 48, sets out what happens, that it's standard practice for the prescribing doctor, this is MS 116 to 117 if your lordships want to look at it, but it's standard practice for the prescribing doctor to prescribe by reference to the generic name of the product in 95% of the cases. And it's rare for prescriptions to identify the condition for which the drug has been.
That had changed as a result of the NHS circular.
It's gone up to 30% branded of 30%. Well, let's be clear about this. It's 30% of cases the prescribing doctor prescribes by reference to the branded product, and it's still only 5% of cases where the prescriptions identify the condition for which the drug has been prescribed.
But the other problem is you can't stop a prescribing chemist saying, I'm awfully sorry, I'm out of stock of this branded. But look, that's just the same. Why don't you take that?
No. Well, there are two problems. If one comes to the dispensing practice, the pharmacist...
Sorry, I should have said dispensing.
Yeah, but when one comes to that, the dispensing pharmacist rarely knows, this is the agreed facts, rarely knows what the indication is for which he or she is dispensing. That's the first problem. The second problem is that on the evidence, the dispensing pharmacist also has a financial interest in dispensing the generic product, because for reasons best known to the NHS, the dispensing pharmacist is compensated by reference to the branded price, whether or not it's the branded product that is dispensed. So my answer to my Lord's first point is that this is not what happens, and the supplier knows very well this is not what happens, and therefore the supplier and the manufacturer, if the manufacturer is informed, knows very well indeed that when it puts on the product that this is has a marketing authorization only for the non-patented indications, it knows perfectly well that a proportion of the product, one can argue about what proportion, but a proportion of the product is going to be dispensed for patented indications.
Does it follow from your submission that every pharmacist is...
No, it doesn't follow from that, because one has to be realistic.
Seems to be implicit in your subsection 60, subsection 2 argument.
Well, one has to be realistic in relation to liability.
What does realism involve? Accepting a degree of leakage.
Well, can I deal... This point is the chilling effect point. It's put by my friends that our approach, which in essence is that the liability of the infringer arises if the infringer knows or can reasonably foresee that a proportion of the product is going to be dispensed for patented indications, the putative infringer, is liable for an account of profits, at the very least, for that proportion of the product. Otherwise, it makes a windfall, and the patentee loses the benefit of that degree of its product. And the case against us, it said, well, this will have a chilling effect down the chain. And we say...
Effectively give you a monopoly of both patented and
Yes,
non-patented
in
indications.
practice, so as you said. And
That's
there's a
not
number
right.
of stages one needs to look at in relation to this. First of all, there's the manufacturer and supplier, and we don't accept that they're going to be inhibited from manufacturing and selling the product for non-patented indications. They're only going to have to provide a remedy for that part of the sales which are, in fact, for the patented indication.
They don't know what that is because they don't know for what purpose the prescription is being given.
Well, they don't know unless agreement can be reached, but this is a standard problem in patent law by reason of strict liability. It will often be the case that there has to be a hearing in relation to these matters. The principle in patent law is that one act of infringement suffices, and at a remedies hearing, these matters need to be addressed. Then it is said that the chilling effect is on the pharmacist. But the reality in our submission is that the pharmacists are given warranties and indemnities by those higher up the supply chain because of the dangers of liability for pharmacy.
Do we know about that? I mean, every pharmacist has a warranty?
Not every
Only
pharmacist.
those
but
employed by the National Health Service.
The problem is a problem inherent in strict liability.
Well, can I just ask how far this goes? I mean, you say that they're indemnified, so be it. But is it your submission that every pharmacist, because he knows there's a risk when he gets a normal prescription, which might be for pain or might be for epilepsy, every pharmacist, because he knows of that risk, is infringing?
No, is my answer.
Well, why isn't that the logic of your argument?
Because one has to take into account the relevant directive on the enforcement of intellectual property rights. And can I invite your Lordship's attention to volume 17 of the authorities? It's tab 210, and it's MS 7071. This is Article 3 of the Directive on the Enforcement of Intellectual Property Rights. MS 7071 at volume 17, tab 210, Article 3, General Obligation. Member States shall provide for the measures, procedures and remedies necessary to ensure the enforcement of the intellectual property rights covered by this directive. Those measures, procedures and remedies shall be fair and equitable, shall not be unnecessarily complicated or costly, or entail unreasonable time limits or unwarranted delays. 2, those measures, procedures and remedies shall also be effective, proportionate and dissuasive, and shall be applied in such a manner as to avoid the creation of barriers to legitimate trade and to provide for safeguards against their abuse. And we accept that that principle must be applied in this context, and we accept that it plainly would not be fair or proportionate to impose a liability against a pharmacist who has dispensed the generic product against a generic prescription.
What could be the provision in domestic law which anyway involves potentially the pharmacist? It has to be section 60 subsection 2, does it? The argument about means.
Yes.
And,
Yes.
But I mean that's quite a contorted argument.
What, for liability for the pharmacist?
Yes.
Yes, I respectfully agree.
Yes.
And,
I mean, maybe it doesn't wash at all.
Well, it would have to be said under section 60 subsection 2 that the pharmacist intends to put the invention into effect in the United Kingdom, and that intention is satisfied in circumstances where the pharmacist only knows that he or she has received a generic prescription without knowing the indication for which the generic prescription has been written by the doctor, and the pharmacist is dispensing the generic product.
So who is the primary infringer for the purposes of Section 60 sub 2?
The primary infringer is the supplier.
On the basis that the invention is the manufacture of the compound for use, a particular use. So it's quite difficult to see how the pharmacist can also be working the invention for that use.
But the person who supplies, you contend, among other things, that Actavis and Mylan are supplying or offering to supply in circumstances covered by Section 60 sub 2, do you not?
We do. In the alternative, yes,
right.
We have two.
Now, the basis of that is that they are said to be supplying or offering to supply the product in circumstances where they know that somebody down the line is going to be infringing. Now, who is that somebody?
Well, our case is that we do not have to identify a specific person, that is either the doctor or the pharmacist. The answer given by Mr. Justice Arnold is that the doctor does not intend, because the doctor prescribes in generic terms. The pharmacist does not intend, because the pharmacist does not know, when the pharmacist dispenses, what the indication is for which the drug is being dispensed. Our answer is that in the context of a Swiss form claim, it is sufficient that those involved lower down the supply chain, that is the doctor and the pharmacist, do intend that the product which is dispensed is to be dispensed for the purpose of the patented indication. That's why the doctor has prescribed. The doctor has prescribed for the purpose of treating the patented indication, even though the doctor has not so stated on the prescription. And we say that is sufficient for our purposes. And that is, to use the language of Section 62, it is putting the invention into effect. That's what matters.
What you say putting the invention into effect means in this context?
Well, in this context, it means that the drug is given to the patient and used.
If a doctor prescribes generically for a patented indication, is he infringing?
The doctor is not infringing, and we accepted that.
But why is that? Because the doctor is prescribing generically for an indication which he knows is subject to a patent. Prescribing generically for, let us say, pain.
It would be difficult to sustain an argument that the doctor is infringing, given Section 4A and the inhibition on recognising a patent for the purposes of medical treatment. That's one of the reasons.
That's a restriction on what can be patented. But the doctor knows that a lawful patent has been given for a particular indication, which is still in force, and yet he prescribes generically. Now, 4A isn't going to help him
Well,
there.
the doctor is not himself supplying or offering to supply the product. The doctor, his involvement is a link in the chain that leads to the pharmacist.
Supplies the means. Isn't the prescription
It's the means.
Yes, he's a component in the supply chain.
Yeah.
Yes.
Because without his prescription,
And it's a generic prescription at that.
But it's got to be the means of putting the invention into effect, and it depends what the invention is, but on the face of it, the invention is the manufacture of the original compound for use rather than the use.
Well, it's
I
the
mean,
manufacture for the purpose. That's
Yes,
the
so
element.
rather than the purpose itself. You only put the doctor on, well,
You put the invention into effect by using it, e.g. by causing a patient to consume it.
Yes. Well, again, we're not suggesting that the doctor is liable. As I say, that would pose a considerable difficulty in terms of Section 4A, if no other difficulty.
I mean, the reality is that this section wasn't drafted with this situation in mind at all.
It's not drafted.
Swiss claims came much later.
It's not
As
drafted
indeed
with
Lord
Swiss.
Hoffman pointed out.
Yes, quite.
No, well, precisely. That's why I took your lordship
Yes.
to the refrigerator. And the difficulty in this case is to arrive at a solution which, in the court's view, best protects the competing interests that arise. And I've accepted that best protecting the competing interests could not sensibly involve liability for the doctor or indeed for the pharmacist who merely dispenses by reference to the generic prescription which the doctor has written. But we are concerned, and we respectfully submit the court should be concerned, as to the liability of the manufacturer and the supplier higher up in the supply chain. And the essential question is whether or not, given the undisputed background material as to prescribing and dispensing practice in this country, and the inevitable consequence from that quantities of the product are being dispensed for patented indications, whether or not my client should have a remedy for the profits that are being made by the generic company by reason of those facts which they know about.
The only way you can avoid infringement on this hypothesis is for the generic manufacturer to stop manufacturing.
Or the supplier to stop supplying.
But that would be true in relation to many products. That is the nature of
Maybe a
patent
perfectly
law.
tolerable result, but it is the result for which you're contending, isn't it?
No, the result for which we are contending is simply that they have to pay us some money. We're not seeking to stop them from manufacturing and supplying
But in that
product,
case-
because they're entitled to
But
manufacture.
in that
whole
case, unless and
difference.
until they do a deal with you, you are saying that they're infringers.
We are saying that they are infringers by reason of their knowledge
Yeah.
of the practical reality.
So if the supplier, desiring to conduct business in a conscientious manner, decides that he ought not to conduct business in a way that means that he's an infringer, then unless he agrees up front before he makes any supplies to any pharmacist, he's going to have, isn't he, he's going to have to decline to make generic supplies of this product.
Well, he's going to have to recognise that in the exceptional circumstances of Swiss form claims, where there are some purposes which are protected by the patent and some which are not, we say, fair solution is that he, the manufacturer, the supplier, will have a liability.
He becomes an accounting
Well,
party. So every month he has to send in
he has a
a
liability.
full account of his business.
He has a
but how is he going to avoid being guilty of a statutory tort other than by coming to a deal with you?
Well, but
I mean,
we say the
wait a
only-
minute. Your product has gone out of patent for epilepsy and it is in patent for pain. The manufacturer wishes to manufacture for epilepsy because of his knowledge, you say, of what's actually happening further down the line. He will be an infringer unless he agrees your terms to do that which the law allows him to do.
Not our terms, with respect, no, because our claim is that he, the manufacturer, is liable for that proportion of his profits
Because he is guilty of a statutory tort.
because in the circumstances...
Well, but if a responsible proprietor, a responsible manufacturer does not wish to be guilty of a statutory tort, is he not subject to your terms, whatever they may be?
But our terms, if your lordship were to accept our submissions, are simply that he's liable to pay an account of profits by reference to the sums that he has obtained from the use of his product for the patented indication.
What surprises me is that we haven't heard more up until now about all the qualifications which have been discussed, in particular in the Court of Appeal. Things like subject to reasonable care having been taken. Now, if the generic manufacturer, because it seems to me, I mean, points are being put to you on the basis the opposition is pretty extreme, but I would have thought you were going to advance some halfway solutions, aren't you?
We have put that position...
I don't know how you're doing for timing, Lord Canning.
I'm very happy to deal with this point.
Well, we're putting a lot of questions to you, and I don't want us to squeeze you
No,
too
not
much.
at all. This is central to the issues between the parties.
Good.
Your lordship is correct that our position is that the best way to ensure a fair balance is that to the extent that the generic manufacturer supplier is profiting from use of the product for patented indications, it should pay an account of
That's
profits.
true.
And
Would
we'd
it be
say
limited to that?
The alternative to that, unless one arrives at some halfway house, the alternative to that is that the generic manufacturer or supplier is going to make a windfall from the use, which it knows about, of its product for patented indications. And therefore, it would be, in my submission, unacceptable for the law to arrive at the position that there is no remedy.
Lord Panic, you say an account of profits, but it would also be open to you, wouldn't it, simply to claim damages equal to the profit that you would have made on the diverted sales.
But I don't want to go that far.
Well, I know, I'm sure you don't, because you're very careful not to make the practical consequences of your submission sound too attractive. But let's take somebody less impeccably reasonable than your clients and suppose that they wanted as much money out of this as they possibly could get. What would stop them claiming simply damages equal to their own loss of profit being the aggregate of the enormous difference between the generic and patented selling price?
Because I'm inviting your lordships to rule that a fair balance between the competing interests could not possibly justify an award of damages. And the reason for that is the reason given by the respondents in their written case, that the profits made by the patentee are larger than the cost of the sale of the generic product, because inherently the original product has to be charged at a price that allows for the investment costs. And therefore, if we were to claim our damages against the respondents by reference to the proportion of sales, that would be inherently unfair. I mean, I recognise that.
See, I mean, we're trying to cram notions of fairness into a damages claim, which are rather unfamiliar. And I mean, it occurs to me, in reality, what you're seeking to do is mount an unjust enrichment claim.
Well, I'm trying to, on behalf of my clients, I'm seeking to
It would be pretty difficult, bearing in mind the lack of the remoteness of the connection.
The difficulty is that Section 60, both in Section 61 and Section 62, does not include any concept of reasonable steps, which is the approach that my Lord Sumption was putting to me earlier, that it might be enough if the generic manufacturer puts on the label not to be used for particular indications. And it's the problem with the solution that's being put to me by my Lord Mance as to a possible solution. But it is a solution that, in the difficult circumstances that we have here of competing interests, the proper test of liability is that the generic manufacturer or supplier must take reasonable steps in the circumstances of this case. We're seeking something more than that, and indeed the argument against us has not been put on the basis that liability in this context should be by reference to reasonable steps. My friends have taken the position that they only have liability if the manufacturer intends to take advantage of the practical realities that its product is going to be used for patented.
Well, in the targeted sense, I think they're saying intention means targeting.
Yes,
Yeah.
yes, that's the competing, your lordships may think, extreme position, and reference is made by my friends to a judgment by my Lord Sumption in Fish and Fish relating to economic torts. And we say that couldn't possibly, with great respect, be a fair solution to the problem. Only if they target are they going to be liable. So your lordships have three possible solutions. Our solution, our preferred solution, which is based on foreseeability and which seeks to tailor the remedy to the proportion of sales which are in fact for the purpose of the patented indication, even though the doctor doesn't specify and the pharmacist doesn't know. At the other extreme, there's an approach based on the intention of the generic manufacturer, or we would say supplier. And there's a third solution, which your lordships have put to me, which is a solution based on an obligation of the manufacturer supplier to take reasonable steps to prevent the use of its product for patented indications.
Could one connect that with some concept of intention? Because, I mean, what would be the position if there was no skinny label and the generic manufacturer simply put the product on the market and said, I suppose then you'd infer an intention to sell it.
You may, if they did.
Generally, to anyone who wanted. So that would be probably sufficient for your purposes.
Yes, yes.
Is it sufficient to put on a skinny label if you know that, in fact, it will be ignored and ineffective?
Well, that's my point by reference to the practical realities, that the practical realities are that doctors do prescribe.
I wonder whether it bore on intention, but perhaps it's quite difficult. But could you say that they must have intended the natural consequences? You can't usually say that.
No, I accept that. If they were not to have a skinny label,
yes, that
then
would
it may be easier to infer an intention to take advantage of the patented indications. But
the intention's quite narrow is the problem.
It is. And I respectfully submit that doesn't secure a fair balance, and therefore the choice is between a reasonable steps approach and the approach for which we contend, which is foreseeability.
There's a more fundamental objection to an intention-based test, which is that it's wholly alien to the general scheme of patent law, as it's always been understood. Indeed, from most purposes, in the general scheme of tort law, because the tort's based on subjective intention. There are several, but they are not the norm.
Well, I respectfully agree. I respectfully adopt what your lordship says in relation to intention. And if the choice then is between the test for which we contend, which is foreseeability, together with a tailored remedy, or reasonable steps, we say that our approach is more consistent with the scheme of the legislation. None of these solutions are perfect in terms of the contents of Section 60. But if one looks at intellectual property law, not just Section 60, if one looks at trademark law and other law, reasonable steps is not a criterion that one finds the legislature having used, whereas knowledge is a criterion that one finds used.
Could you help me on your tailored remedy?
Yes, ma'am.
I have a practical problem. As I understand it, your approach effectively would create an infringement liability on pretty well every supplier into the UK because of his inability to be satisfied that a pharmacist who buys down the line isn't going to dispense the generic product for pain.
On the facts as they existed at the relevant time relating
Yes.
to dispensing and prescribing practice,
Then
I
you,
accept that.
Then you say the courts can temper the wind to the shorn lamb by saying, well, you're only going to be liable either for an account of profits or damages in relation to the sales of your generic product that actually did get used or dispensed for pain. But it's of the essence of the problem, which leads to your foreseeability solution, that nobody knows what proportion of the generic is being dispensed for the use of pain. How is the court going to act in this temperate fashion to mitigate the rigour of your liability approach if it almost by definition isn't going to have the materials with which to be able to do so?
My answer to my lord is that this is not a unique problem in patent law, and the courts have addressed this in the Grimm case. Can I take your lordship so your lordship can see how the Court of Appeal dealt with it? It's volume 13, it's tab 158, and the report begins at MS 5927. This is the Court of Appeal. It's Lord Justice Jacob giving the judgment of the Court of Appeal. And the context here is indirect infringement. The case concerns, as your lordships can see from the head note, it concerns a patent for machines for separating potatoes from weeds and earth using a rubber roller. That's the nature of the patent. And the issue in the case was whether a machine sold with an interchangeable steel roller indirectly infringed the patent.
I think I got the wrong page. Can you give me?
Yes, my lord. It starts at MS 5927.
Thank you.
Volume 13, and it's tab 158.
Yes.
Court of Appeal, Grimm against Scott. And it's an indirect infringement case. Was the defendant supplying essential means for putting the invention into effect when it supplies the product with an interchangeable steel roller? And if your court would go, please, to paragraph 76, which is MS 5949. Paragraph 76, Lord Justice Jacob says that the evidence was that it was very rare for machines originally supplied with steel rollers to be switched, in other words, switched by the customer. And 4 lines down, the point was not explored any further in the evidence. We do not deprecate that. The extent of switching in the real world is a matter which at this stage is premature. It arises on an inquiry as to damages. For present purposes, we proceed on the basis that switching sometimes happens. It's hardly surprising it happens, since convertibility was the selling feature. The presumption must be Mr. Scott enhanced his sales by virtue of that feature, not necessary to have an intention. And then at paragraph 88, which is 5951, MS 5951, his lordship addresses section 62, and Lord Justice Jacob explains, section 62 creates a statutory tort. Its distinctive features, by way of contrast with common law tortious claims, are that the tort is actionable even though what is supplied is perfectly capable of perfectly lawful, non-infringing use, even though what it's supplied never has been, may never in fact be used in a way directly infringing the patent in suit, without any damage being suffered by the patentee, and at the moment of supply, irrespective of anything that may or may not occur afterwards. And then if one goes to remedies, and one turns please to paragraphs 112, MS 5955, his lordship at paragraph 112 is dealing with the nature of liability under section 62. What then, he says at paragraph 112, of the inherently probable view, this was essentially that for which counsel argued, he submitted it was enough if the supplier knew, or it was obvious in the circumstances at the time of his offer to supply or supply, that some, emphasis added, disregarding freak use, ultimate users would intend to use, adapt or alter the means essential so as to infringe. And at 114, his lordship concludes that is the correct approach. And thereafter, there's a lot of references to various continental law explaining why that is the correct approach. Then his lordship comes to remedies at MS 5958, paragraph 133, where his lordship says the case has only got to the point of considering liability, and thus whether or not there was contributory infringement in principle. However, it may be helpful if we express some preliminary views about remedies. And over the page, 5959, paragraph 136, as to financial remedies, whether by way of damages or on account of profits, we are strongly inclined to think that the defendant's sales should not be treated in the same way as if they were sales of products which actually infringe. After all, the products do not infringe in themselves, only a proportion may ever be modified so as to infringe, and only a proportion of ultimate customers may have bought with any intention, even condition, so to modify. That raises the difficult question of how quantum of damages or profits is to be assessed. It would seem to depend on the degree to which ultimate users adapt or intend to adapt the device so as to infringe. One could simply apply the proportion which is adapted to infringe as the proportion of the defendant's sales which should be treated as infringing. Another view would be that the real question depends on how much the defendant augmented his sales by virtue of his contributory infringement. That would be difficult to assess, but might as a working rule start with the same proportion. Now, we rely on all of that as indicating that in other patent contexts, it's true, an indirect infringement context, it is sufficient to establish liability to show that some ultimate users will use the product in a way which infringes the patent.
Is it implicit in your submission that you can't get an injunction to restrain the infringement which you say happened in this case? So
I accept...
no injunction and no damages.
I accept that if one's searching for a fair balance here, it could not be right for us to obtain an injunction to restrain the manufacture supply of a product for which there is a public interest in the use of the products for non-patented indications. I entirely accept that, unless the defendant manufacturer or supplier is seeking to take advantage. That's its purpose, is seeking to take advantage of patented indications. In those circumstances, an injunction may be available, but not in other cases. So I say that Grimm establishes that in some patent contexts at least, one looks to see whether some ultimate users will use the product in a manner which infringes the patent. I say secondly, it shows that the extent of infringement is a matter for the remedies stage, and one doesn't need to concern oneself about the extent of the infringement at the stage of liability. And thirdly, it shows that it can be appropriate for the court to seek to assess the remedy by reference to the proportion of the use of the product, which in fact infringes the patent. So what we're suggesting is not unprecedented. I don't suggest the case is on all fours with Swiss form use, but it's close enough to indicate that these problems, and they are problems, I don't take issue with your Lordship, my Lord Briggs, putting to me that these are problems. I say, however, that they are problems that occur elsewhere in patent law, in which the court has sought.
It doesn't look there in the Grimmy case that there was a sort of balancing of the efficacy of the supposed tempering of the wind against the proper analysis in this very difficult field of the extent of the liability for infringement in the first place.
The context is different, and I have to accept that in Grimm the court took the view that the manufacturer was seeking to take advantage of the potential, to put it at its lowest.
There was an element of targeting.
For users to adopt the approach that would amount to an infringement. But I show the case to your Lordship, so your Lordship court appreciates that problems of this nature do occur in patent law, and the court has been prepared to adopt the sort of approach for which I contend.
Can I ask you this? In Grimm, the court's approach to section 60, subsection 2, appears to have been that the relevant intention was that of the person to whom the infringer supplied
the end user,
the goods, the end user. Yeah. So the mental element, so far as the infringer was concerned, was knowledge, and the knowledge included knowledge of the intention of the end user.
Yes.
And so the parallel here would be the relevant intention is that of the pharmacist, and the relevant knowledge is knowledge on the part of the supplier as to the pharmacist's intention.
In my respectful submission, it's more complicated than that, because the pharmacist does not intend to do other than dispense the generic product without knowing the indication for which it's being dispensed. And therefore, for my purposes, I have to say, in order to bring the case within section 62, that the end user is a combination of the intentions of the doctor, which is, I am prescribing a drug for a patented indication, combined with the practice of the pharmacist of dispensing the generic product because the prescription's been written in generic terms. But there's, in my submission, there is no doubt it is the doctor who intends to treat the patented indication. And of course the patient intends to take the product.
But the doctor would have to, am I getting this wrong? The doctor would have to intend the use of the generic drug for the patented indication.
Well, the doctor undoubtedly does intend that the product which is dispensed is for the purpose of the patented indication. I mean, the doctor has no interest in which product is dispensed. The doctor simply writes. The doctor writes the prescription.
He is saying, I'm happy that the generic product should be used for the patented indication.
Yes, well, he's saying, I've written a prescription in generic terms. I suppose one could say of the doctor, he knows perfectly well that the pharmacist, therefore, in 95% of cases, will not know the indication, and that the overwhelming likelihood is that the pharmacist is therefore going to dispense, because it's in his financial interest to do so, the generic product. And I say that's sufficient for section 62, the intention of the end user, that the doctor intends to prescribe for patented indications. It's true he doesn't make that clear on the prescription, and it's true that the pharmacist doesn't therefore know the patented indication. But that's the purpose of the prescription. And it's the reason why the end user, the patient, takes the drug that he's been prescribed and which has been dispensed. So that's how we put it for the purposes of section 60.
Lord Pannick, we've concentrated on section 62.
Yes.
I had understood your case to be put also on section 61C.
Oh yes, indeed. And I'd made...
And indeed, my understanding is that your case would ordinarily, as against the manufacturer or the supplier, be under 61C.
Yes, it would. Yes. Oh, I don't wish to give the impression, my Lord, by talking about section 62 in any way that I'm not putting at the forefront of our case, in addition, section 61C. I'd focused on section 62 because the ingredients are more complex. And the Grimm case is an indirect infringement case.
How do you say C applies? You have to have a product obtained directly by means of the patented process.
Well, the product is the drug. It is obtained. The tablet is obtained directly by means of the patented process.
By manufacturing it with a use in mind.
Yes.
For a use.
Yes. And I say we fall fairly and squarely within section 61C. The difficulty is that I accept, and I have to accept, and I fairly accept, that of course one needs to add something in a Swiss form case to section 61C because I acknowledge the need to ensure that the generic manufacturer and supplier must be able to manufacture and sell the product for the non-patented indications, and therefore one has to read something into section 61C in order for it to make sense in the Swiss form case.
So, can you remind me where in your written case you tell us what you think we should read into 61C?
Well, it's the knowledge criterion. It's where they know that the product is going to be dispensed for a patented indication.
But then that applies to the whole of the the whole of the supply of that generic.
I'm sorry, Laura.
That then applies to the whole of the supply of that generic.
Which is why, in my submission, in a case where the generic manufacturer or supplier knows, as will be the case, I accept, that at least a proportion of its product is going to be used for the patented indication, one can only balance the competing interests by tailoring a remedy of the sort that I've sought to indicate.
I think you accept in principle, don't you, that under 61C, any supply by that supplier, or any and every packet supplied would be an infringing supply.
Well, I don't accept every packet because one would have to identify, and it's often a difficulty in patent law to identify which packets are going to be used for the infringing purposes.
But it's the knowledge that it may be, surely, that makes the supply of that packet infringing. And you can't say in relation to any one packet whether it will or won't.
You certainly can't say that. And that's why I've accepted that there will be a liability. I propose that there will be a liability by reason of the manufacturer-supplier manufacturing and supplying the product in a Swiss form case of this nature by reason of prescribing and dispensing practice. It follows, this is our case, it follows that a proportion of the product will be used for patented indications. And I have sought to persuade your lordships that the best solution, the solution which achieves a fair balance in a very, very difficult area where patent law is not designed to address these problems, manifestly not designed to address these problems, is to focus on remedies and to ensure that we receive a remedy for the proportion of the sales which are for the patented indication, and the generic company, it doesn't end up with a windfall for the use of its product for those patented indications.
I'm just thinking of analogies. Is there any other field that you can identify in which an act is tortious, but damages will not be, as a matter of principle, allowed? Only other remedies?
I find it difficult to find such analogies, partly because this is an area where the legality of the conduct depends upon the purpose, the use to which the product is put. And it's very difficult in areas where there are two private persons to identify such circumstances. But the answer to your Lordship's question is no, we've not found any analogies. We've not found any authority which addresses this sort of problem either way. And that's why it's a difficult question. There are foreign judgments which have sought to address these problems. I noticed the time. I think I have 5 minutes of my allocation left, but it may be...
Why don't you, do you want to do it afterwards?
Well, what I was going to suggest,
some
I've
time left
raised
now.
this with my friend, if I take extra time, and I won't take very much extra time, then it will come out of our allocation for reply. And my friends are content with that if the court is content with it. And therefore, it may be helpful after the adjournment, just very briefly, to show your lordships the other European jurisdiction judgments, 2 or 3 of them, which have addressed this problem. I don't suggest they provide solutions, but they show that the problem has been recognised elsewhere, and a variety of solutions have been offered.
Or do you want to start on them?
Well, can I? Yes. Shall I start on them and then?
Can I just ask you, before you leave it, I just wonder if it may not be a bit too simple to treat the product under C as being simply the tablets. C applies where the invention is a process. The process here, as I understand it, is the use of the molecule in the manufacture of a product suitable for, not suitable for, designed for the treatment of pain.
Yes.
So it's the whole point of the invention is that what you are producing is something designed as a painkiller, as an analgesic. So the prohibition in C is on the disposal of any product obtained directly by means of that process. So one might have thought that a product obtained by means of that process would be a product intended for use in the treatment of pain.
Well, it doesn't say the element of intention is not included in C,
No,
and
it's
indeed
included in the invention. That's the whole point of the invention.
well, the point of the invention is a product which is for a particular use.
For, you told us, meant
For the purpose
intended
of.
for or designed for?
For the purpose of, yes, as opposed to merely suitable
Yeah.
for.
Yeah.
Yes, but for the purpose of, a synonym for that might be targeted at.
Well, that's where we take issue. That's where we take issue. That the
Well, what is it? What is for the purpose of then?
well, for the purpose of means that it is for that use. For that use, but it doesn't mean that in the definition under section 61C, the product is defined in that way. The product is the tablet which has been produced by the manufacturing
I doubt
process.
it. I mean, say, for example, the tablets came in a box that said, or packet that said, suitable for use in the treatment of epilepsy and anxiety disorders. Now, how could one describe that as a product for the purpose of treating pain?
Well, but section 61C takes as the premise that the invention is a process, and it then looks at disposal or use of any product obtained directly by means of that process. And my submission is that the product is simply the tablet.
Well, the trouble
Well,
is
yes, the product is something which has been manufactured for...
It's the physical entity.
for use for a particular purpose. And so you can't separate the product from either the manufacturer or the purpose.
Yes, I mean, the problem is if you finesse out what the whole point of the invention is, then you get into the problems that we're having.
But the difficulty that then arises is that nevertheless, the product is being used to the knowledge of the manufacturer or supplier.
In a way which is going to cause loss. Yes.
For the prohibited, not prohibited, but for the protected purpose.
You say regardless both of the label on the box, which is probably a form of skinny label, or indeed the the use instructions leaflet, which I hope we can all take some real-world notice of, doesn't often get read.
Well, those are the findings of fact. I mean, there's no dispute about it, that in the circumstances,
It's inevitable in Lord Justice Jacobs' terms.
Yes.
Well, I think probably it's inevitable that we adjourn until 2 o'clock.
Thank you very much.